bulletin right now. Now, of course, everybody knows that the EB2 remains, the filing dates remain the same. But when it comes to EB3, the filing dates, which were there until January 1st of 2015, has moved to January of 2014. And we already know, Rebecca, that that the USCIS is accepting the filing dates for the month of December, like the way they did it in October, like the way they did in November. They are going to do the same thing in December. Now, what about the people, if people have not already filed the adjustment of status and the priority date falls under between January 1st of 2014 to January 1st of 2015, can they still file the adjustment of status in November, Rebecca?
Yes. Hopefully there aren't too many people in that category. Hopefully it would have already been filed in October or November, but if you have not filed the I-485 yet and your priority date for EB3 falls between January 2014 and January 2015, it is still possible to file in November. So you have 9 days to get that taken care of.
Can they file, those people between January 2014 and January 2015? Can they file in can they file in December, or they cannot?
They can't. So those new numbers for December will be effective December 1st.
What about the people who have already filed? Most of them have not received the receipt notice. According to the Immigration Lawyers Association, it's taking approximately 6 weeks to get the receipt notice. So do they have to get the receipt notice before December 1st, or can they get it after December 1st?
Yeah, when the receipt notice arrives does not affect which month governs your I-485 application or which month's visa bulletin. As long as your application reached USCIS in October or November, then those dates are, that chart is the one that applies to your application. So yeah, we expect the I-485 receipt notices to take, I'm predicting longer than 6 weeks because we filed some in the very first week of October and did not get the receipt notice until just this past week. And so that was before the main rush of applications that were being filed in October. So I'm expecting it to take longer, but even if your receipt notice arrives in December, January, the receipt date on there should be the date that it was delivered to the service center, which should be October or November, and those visa bulletin dates are the ones that will apply.
What about the EAD and advance parole that the people have filed? Will they be adjudicated now? Will they be approved now? Now the priority date has backlogged for at least some people.
As long as the I-765 and I-131 applications were filed with an I-485 that was filed based on a date that was current in the month that it arrived at USCIS, then those will be processed. They won't hold processing an I-765 just because the date's retrogressed.
You mean to say EAD and advance parole, they will still
Right.
adjudicate. If some
Right.
of the people have not filed the EAD and advance parole, can they still file the EAD and advance parole right now, even if the priority date has backlogged once they have a receipt notice?
Yes. So all you need to file the EAD and AP application is an I-485 receipt notice. Even if the month that you're submitting the EAD AP application, even if your date is no longer current according to that month's bulletin, as long as you have an I-485 receipt notice, that means your I-485 was filed in a month where it was current. And as long as that is the case, then you can submit the EAD AP application at any time while the I-485 application is pending.
Most of the people have filed the downgrade application from I-140 and adjustment of status, Rebecca. For those people, is it necessary for them to have an I-140 approved before they get an EAD in advance parole?
No. So the EAD and AP are processed kind of separately from the I-140 application. So it's possible for the I-140 to still be pending. And if the EAD AP are processed faster, you could get the EAD and AP card before the I-140 is approved.
Rebecca, let's move to the different topic, and then we'll come back to the things where, especially a lot of people are now hopeful that the Biden administration is going to come into power on January 20th of 2020. There are a couple of things that are bothering the immigrants right now, especially the big consulting companies from India. They are not even filing any extensions until the prevailing wages things have been sorted out in the court. They are reluctant to use the alternative wage survey. The first question that I have for you is that, have your firm filed anything with the alternative wage survey? Did you get any approvals with the alternative wage surveys?
Yes, we have. So we've filed several applications since October 8th using alternative wage surveys, and we have gotten approvals for those for some that were submitted in premium processing. We understand the alternative, kind of the hesitance about using alternative wage surveys because it hasn't been the common practice for many years for H-1B processing, but the alternative wage survey is actually not a new concept. It's just that most applicants haven't needed to use it so far as the OFLC was reasonable. But the option to use an alternative wage survey has always been there for many years.
Rebecca, there are three main things. One is the wage survey. And on December 8th, we have new regulations that are becoming effective. The new regulations restrict mostly, they redefine the specialty occupation, H-1B. So we are expecting some strict interpretations of that. And also on the December 8th, we have the new regulations that are becoming effective, especially for the consulting companies where after the ITServe litigation, we are starting getting approvals 3 years for it. It's been a long time, and we've been getting routinely 3 years H-1B approvals for the consulting companies when companies place individuals at third-party location. But the new regulations, which are becoming effective on December 8th, are restricting that the H-1 approval should be only approved and only 1 year. Now, we have another problem, especially for the H-4 EAD. The processing time, according to the California Service Center, is 20 months. So practically H-4 EAD will be dead if they do the processing times as 20 months. Because 1 year of H-1B approval plus 20 months of this one, they will never get an EAD approval in a proper timing. Now the Biden administration is coming. Do you expect in the next, as soon as they come in, they will undo the prevailing wage? That's my first question. I'll go to the next question.
No, I would be very surprised if they took action to reverse this prevailing wage rule. Even if they wanted to, it's not something that can be undone very quickly by a new administration because it was issued as a regulation. So in order for them to change it, even if they wanted to, they would need to go through the regulatory process. I would say that it's more likely going to, the solution to this wage rule problem is more likely going to come through the courts, through a court looking at it and all the problems with the rule, the problems with how it was issued, with the substance of it, and a judge deciding to, hopefully pretty soon, any day now, to put a preliminary injunction on using it, and then eventually, hopefully, it will be struck down. Where the Biden administration could be helpful in that regard is that if the court decision to strike down the prevailing wage rule occurs during a Biden administration, our guess is that most likely that administration wouldn't fight that court ruling that much, but we don't expect them to take affirmative action to go and undo this.
What about the specialty occupation and the short-term approvals? The regulations are becoming effective. These regulations are becoming effective for the cases that we're going to file on December 8th or afterwards. What about them? What do you expect? Do you expect with the Biden administration affirmatively take an action and undo the regulations, or we'll have to just rely on the courts again?
I think we're going to need to rely on the courts again for the specialty occupation regulation. Again, it's, the Biden administration has made statements on their intentions to act swiftly on certain areas of immigration within, pretty quickly when they start on January 20th. However, those areas are ones that, for the most part, don't affect employment-based immigration. It's sort of the more, the issues that have been in the headlines more, the ones that I would say most Americans tend to agree on, as such as the family separation issues, some of the kind of extreme measures related to asylum that the Trump administration has taken. Those are the types of areas where the Biden administration is planning to take affirmative action to actually undo what the Trump administration has done. I don't really see them taking that same sort of positive action in the employment-based area because, President-elect Biden's base is also made up of labor unions, blue-collar American workers. Part of his constituency is workers who are looking to protect American workers and concerned about things like that. So they're unlikely to kind of make big actions to undo some of that.
Rebecca, we have seen the Trump administration bring in the biometrics. We have seen the Trump administration bring in the social media in the DS-160 when people apply for the visa. We have seen this administration try to increase the fees. We have seen this administration change the forms so frequently. Sometimes by the time we get the new form, then we have another form. We have seen recently some policy changes on the Child Protective Act interpretations. We have also seen now that the F1 visa regulations were being issued, commenting period is getting over. The Trump administration can make these regulations, especially if the F1 visa person comes into United States, joins a university. If he wants to change to a different university, he has to file an I-539 application, which the processing time is anywhere between 10 months to 20 months. And if they want to get an OPT after they complete their education, they may have to file an I-539 for getting an OPT, and a STEM extension, they may have to file an I-539. Can this administration publish these regulations right now? And can this administration do any more damage before he leaves the office?
Unfortunately, yes. Until January 20th, at least, the current administration is still the administration in power, and they can act, as much as they are able to for the next, 2 months or so. And yeah, unfortunately, it kind of the way that this administration operates, it doesn't surprise us that much that they are, even if they do eventually concede the election and know that they're on the way out, they are not going to go quietly. They're going to do as much damage as they can, especially in an area like immigration that was central to the president's campaign and platform. Yeah, like the policy memo updates that just came out in the past week or so are kind of examples of that, of just throwing in as much as they can to make things as difficult as possible for immigrants, for employers, anyone involved in this process, while they are still in power.
Rebecca, after all the bad things that the Trump administration has done, not that he wanted to do any benefit for the employment based, but luckily the Indians and some part Chinese nationals got benefited because of the ban of the immigrants coming from outside the country, and the family preference categories fell into the employment based. Now, The year, as people already know, that the year of 2021 for the USCIS or the State Department starts on October 1st. So we still have the executive order effect until December 31st. So that means that October, November, and December, that is approximately 1/4 of the entire year, we do have the family ban. If you look into the Trump administration, they started doing in June or April or June, I'm sorry, April. So they did the 8 months ban, did positively affect the Indians in a way because the priority dates are moved right now. Do you see that even if the Biden administration comes in, that the US consulate may not immediately open and grant the green card applications? So the unused family immigration, even if the Biden administration wants it or not, could Indians be benefited by this pandemic because of the Trump executive order and also the COVID?
Yes, possibly. So, this kind of extraordinary shift in the priority dates that we saw in October was in large part, as Rahul said, due to the lack of family-based green cards being issued at consulates, partly as a result of the president's executive order and the COVID pandemic. And that was, April to October. Going forward right now, that executive order is still in place. The pandemic has still significantly limited applications at the majority of consulates worldwide. Most consulates are taking emergency appointments only right now, and the earliest appointments that they are accepting are in the spring, and those could be rescheduled. So yeah, the sort of in effect, the lack of green cards being issued next year as a result of the pandemic could lead to something similar, more unused family-based green cards spilling over into the employment-based category like we saw in October at the beginning of this fiscal year.
Before I get to Q&As, I just want to give a couple of advices that the new regulations are becoming effective, especially the specialty occupation and the short-term approval for the consulting companies on if you file an application on or after December 8th. So if you file an application before December 8th, you don't fall into the new regulation. So if your extension is about to be filed, please file an extension before December 8th so that you don't come into the new regulation. I also want to refer, I will use the word called marriage to the downgrade applications. I know that a lot of people will have the questions on it, and I will tell you what this word marriage is. We have conducted, Houston Desi Foundation has conducted the conference call, the Zoom meeting before. If you want to refer to that video, Kishore has put that in the YouTube. I'll refer this marriage word. That means that if you maintain the non-immigrant visa application, you will have a flexibility of doing what you want. But if you don't maintain the non-immigrant visa, that means that if you either use an EAD or if you use an advance parole, we consider that you are considered to be married to this adjustment of status. If you file an adjustment of status, and if you file an EAD application, and if you file an advance parole and you don't use it, you are just flirting with this adjustment of status application. You are not considered to be married to this application. So I want you to remember this word marriage, because I am going to refer that very frequently. When you ask a question, whether or not you will be married to this application will be something that I will like you to refer the word marriage. And also for the people who have kids, who are, let's say, above 15, I would say that we do not want these above 15 age kids who are in the adjustment of status to get married to this adjustment of status application. We may want them to not get married to this application because if the adjustment of status final action date doesn't become current, the kids will be kicked out of the application. In Hindi, we call it, if they get kicked out of the application, they don't maintain the non-immigrant visa. I have to use this Hindi sentence, you will be na gar ka, na ghat ka. So for that reason, we do not want these kids who are in adjustment of status get married to this adjustment of status, because they will lose a non-immigrant visa and they may be kicked out. And we get some of the calls. A lady called in my conference call and she says that, look, I've been kicked out of this application. My younger two siblings got the green card. My parents got the green card, but I did not get the green card. I'm out of status. What to do? This situation may arise for your kid. We want you to be very careful whether or not you will or your kid should get married to this application. If your kid is above 15, if you're trying to use a non-immigrant, if you're trying to use the E8 and AP, we would want you to consult a lawyer, go through the things to see if you really want to use the E8 and AP application. Kishore, we can go to Q&As if you want to.
Yeah, sure, Rahul. Let me unmute Satyanarayana Krishnamurthy. You are unmuted.
Hello, thank you, Kishore, and thanks Rahul and Rebecca for useful information. My question is more from this DHS ahead, the Chad Wolf. Recently, the New York court said that his appointment is unlawful, and all these decisions related to the wage reviews and specialty occupations have been done under his administration. So, because the court ruled his appointment as unlawful, will the decisions that is taken under his administration will also become illegitimate?
First thing is that the wage rule comes from the DOL, not from the DHS. So that's definitely out, though. With regards to the H-1B specialty occupation, and with regards to the short-term approval, though, just because his appointment is illegal doesn't make the entire department, every action illegal by default. I mean, they have granted green cards, they have granted H-1B approvals, they have granted the denials of the H-1B. Can all these things can be considered illegal because it is done under this administration? No, I don't think so. That by itself is enough to get the H-1B approvals, which they did it, H-1B denials, they did it. Can they just be reversed because the head has been cut off? No, I don't think so. Rebecca, do you feel anything different on that?
But it's a policy change. That's where my question, was.
That's the reason I'm referring to
Sure.
Rebecca.
Yeah, you're right. A federal judge did kind of agree with that reasoning, and throughout, I think that case was related to DACA, some of his policy on DACA applications. I know that the agency has been trying to retroactively remedy some of that by, they apparently kind of have gotten the FEMA, head of FEMA, who would actually be the next legal person in line to try to sign off retroactively on some of those policy changes by Chad Wolf in order to try to legitimize them. And I think the court is still deciding on that. Yeah, I think it is, it's a valid question, although whether that alone will be enough to strike down every policy change, I think is, yeah, it'll be up to a judge. That New York federal judge is obviously favorable to that argument. We don't know how a circuit court judge or anyone else would, another district judge would look at that. I would say that the challenge to the prevailing wage rule and the specialty occupation rule, that is one avenue of legal challenge that I would definitely include in a court challenge. And there are lawsuits on the prevailing wage that have already been filed. But I think a much stronger basis, there are other stronger bases for a judge to strike down or at least put an injunction on both of these rules. Just the substance of the wage rule itself is just so arbitrary and unreasonable that I think almost any federal judge would agree with that. In addition to that, the way that it was issued was hugely problematic. To issue it without warning as an interim final rule that went into effect almost immediately. There is a very high standard for why a rule would be issued that way, and it's very unlikely the government would be able to meet that threshold. So I think there are other better legal ways to attack that rule, although I would throw in the Chad Wolf issue.
When we make an argument, though, yes, we throw the lawyers will throw every argument that possibly they can. Some things might work out, some things may not, but as Rebecca has pointed out, that argument will be thrown out, will be put into. But Rebecca, with regards to the specialty occupation and with regards to the short-term approval, no case, federal court case has yet been filed. Now, as the audience, as Satyanarayana Murthy has pointed out, could that be a great argument there, especially this is coming from his administration, the policy things?
Yeah.
Or could they refer back to saying that it was already in the pipeline since the time the executive order had been issued when Trump administration came into picture, when this guy was not there?
Yeah, that would probably be something the government would argue. Actually, that is true that there have been sort of plans for changes to the H-1B specialty occupation for a while. So the government could argue that those intended regulatory changes predated Chad Wolf and his acting head of the agency. There aren't any lawsuits on that rule yet because it hasn't gone into effect yet. So a lawsuit cannot be filed until there has been some sort of harm done to a party who can sue based on it. Technically, the harm to H-1B employers and employees won't technically occur until January 7th or 8th when the rule goes into effect. So
December.
That's why they're
December.
December. December. But I would say definitely there are groups that are planning litigation and preparing to file lawsuits based on it as soon as it comes into effect.
You sure?
Yeah. So we are getting some questions from Facebook Live also.
Okay.
So I have an approved I-130 for my brother with priority date of April 1st, 2009 and notice date of October 19th, 2010. Case is with NVC, but my brother moved to Italy and he is a permanent resident of Italy from 2019.
Mm-hmm.
So do we need to move the beneficiary address to Italy now? And can he get his US permanent residency quickly because he is he got PR with Italy now?
Well, it doesn't make definitely moving the address from India to there. It's going to be a very big problem. Rebecca, do you feel we should move or maybe just have this guy go to India and get the green card there? He's still an Indian citizen.
Yeah.
Right. Yeah, if it is this close to being issued, probably keeping it at the same consulate would be best.
Because if you try to change to Italy consulate, you can, but the entire process is going to take entire process might take a long time. We may have to file a thing called I-824, and the processing time is about 1.5 to 2 years. So considering these factors and the way that the NVC does this thing, I am reluctant to move it to Italy. I would rather have this guy fly to India with his family and get the green card. If he has to fly 2 times, I will have him fly 2 times to get the things done in India rather than moving it to Italy. Otherwise, he'll waste two of it, maybe 2+ years still.
Yeah. Ramesh, you're unmuted.
Yes, sure. Yeah, thanks for unmuting. And sure. I have a situation for my I-140. I am with the employer. I-140 got approved with them in.
We can't hear you.
Are you there, Ramesh?
And C and D are both are affiliates. So can I make use of existing 140 to file the adjustment status, or can I need to file a PERM again?
You're saying that you have an old I-140 approval with company A, and now
Correct.
you're working with company B, and you're telling both are affiliates. What do you mean by
No.
affiliates?
No. Now I am with D, and C and D are affiliates, but A got merged with B, B got merged with C, and C and D are affiliates. Means my current employer is 8K miles Health Cloud, and the C is 8K miles Software Services. Both are under same administration.
But who filed your labor and I-140 before?
That's with Gray Matter in 2014, and
So
that is
has
no
nothing
more
to do.
existence.
So, okay. So if that company is no more existence, your current company, either 8K, either of those companies that you're saying two companies, right? Either of those companies can file a PERM and I-140 for you.
I cannot use directly successor interest amendment, and can I use it? Or?
No, you said that the previous company that filed the labor and I-140 doesn't even exist, and that has no relationship with 8K.
No, there is a relation with software service, 8K software services, but I am with 8K Health Cloud. But my perspective.
Wait. Your original application that was filed with company A and the 8K software services, what relationship is there?
A we merge with B, that is Idle Solutions, and B is merged with 8K software services.
Okay, we have to look into all those things. That looks very sketchy to me because there is like it's not like A to software services. It looks like there is a B. So there is a successor. There should be a successor of interest from A to B and B to this software services. In which case, Rebecca, are you comfortable in filing an I-140 amendment, or do you need to do labor approval? I'm thinking of filing another labor.
Yeah, even I've been following with them from since the B is merged with C in 2018, but they were saying their immigration team in the internal in-house immigration team, they were saying you no need to do that. We can make use of existing one.
Yeah,
and
we
now
have to look
when the time comes, when the time comes, now the dates are moving, and I wanted to make use of that. Now they are saying, reviewing all the documents. No, we cannot make use of that. You have to go with the labor again. I said, if you want to do labor again, it will take one more year, right?
Well,
so
you don't have much options.
Yeah, that's the reason I wanted to check. Like, is there any possibility we can make use of existing one?
We have to look into all the successor of interest, how the A merged into B, how the B merged into C. But it's looking very sketchy. I haven't done anything A to C at this point of time. I haven't done a I-140 amendment from A to C in your case. I've done A to B if the successor of interest is there, but A to C, I haven't done it. I still need to look into it. It'll be very risky if you do it.
Okay. So you would advise me to go ahead with the fresh labor?
Fresh labor certification, yes.
Okay. Thank you, sir.
Thank you, Ramesh.
Yeah, next question is from Mr. Rajkumar. Please guide me whether we can apply for second visa extension beyond our 1 year stay. We have applied for first extension in April, but still that is under progress.
You can technically do it right now because of the pandemic situation. We never recommend people filing a B2 extension unless it's a very medical emergency. But it seems that everybody's in medical emergency right now. They could file, but if they can avoid it, if they can send them back though, I would recommend to send them back. The reason is that you may be able to live this day, but the problem is the chances for them to come back from India back again, at least for the next 2 to 3 years, will be completely closed. They should not even try to come back if they try to do the extension. But to answer the question, technically they can, but not recommended. Kishore.
Yeah, thanks, Rahul. Mr. Yogesh, you can, yeah.
Thank you, Kishore and Rahul. Is my voice audible?
Yes.
Yes, very good.
So Rahul, my question is like we saw the big movement based on the leftover visas from family based last year in the first quarter of 2021.
Of course.
So if I understand correctly, the visas available was about 120,000 or 140,000, but USCIS has a policy not to use minimum like 25% of the volume. So
What?
can we 25% of the visas can be used every quarter? I don't know that concept, but you may be having some more knowledge on it. So all the 120,000 which were available has not been used for the dates movement. Is that a true statement, or my understanding is correct?
Yes. When we file that, your understanding is to an extent correct. Let me explain the people what this 25% rule, what he's speaking about is that the entire green cards that are available is 140,000 plus, I think so it's about 100,000 that has been granted because of the family immigration. So it's approximately 240,000. They can't give all the green card in one quarter, okay? And they can't sit down the entire 3 quarters doing nothing. So that's the reason they normally grant 25% every quarter. However, one thing I want you to remember is that just by filing an application of the adjustment of status doesn't mean that the numbers are being used. It is when they grant the green cards, the number will be considered to have been used.
Okay.
You got the point? So we
Yes.
file all these applications that probably will fill all the 250 plus thousand, green cards, that even more than that, maybe not. I don't know exact numbers. But it doesn't mean that when we filed it, they use a 25% or 50% or 100%. They haven't used it. It will be used only when they start adjudicating those applications.
Okay. So my question comes second is that can we see the similar kind of movement in the first quarter, like January or January visa bulletin?
No, we are not expecting at all. We are not expecting any movement forward, especially the filing dates. We are not expecting at all. We expected filing dates to be studied the entire year, but for some reason they did not do that. We are anticipating that the final action dates will move forward for EB1, for EB2, and EB3. We already see some EB2 movement already, okay? But we are not expecting the filing dates to be moved at least until July.
At least until July. Okay.
And in July, we will, if based on the number of applications that have been filed, we may expect, it is expected some movement, but at this point of time, I'm not expecting any movement of the filing dates until September of 2020. I have gone wrong. I hope I go wrong in this one again. Rebecca, what's your feel on that?
Yeah, I agree. The reason for that is that the filing dates that the government puts out in October in that chart B, the filing dates chart, that is always farther ahead than chart A, because that's where the government projects by the end of the fiscal year, the final action dates chart will be. So that's kind of the whole rationale behind having chart B, a filing dates chart, to allow people to start filing the applications that they expect can be processed in the next year, so that by the end of that fiscal year, they have those applications and that they're theoretically processed. In reality, all those I-485s are likely not going to be processed within the year, but at least that's where the government projects that the date, the movement of the final action dates are supposed to be. So that's why the filing dates chart usually does not move forward that much during the fiscal year, because when they publish it in October, they're saying by September 2021, this is where we expect final action dates to be. If it moves, it could move backward like it did in December if they receive more applications than they expected to in October, which I expect is why they moved the dates back a bit. And they could possibly move forward a bit, like Rahul said, in the summer, because by then they'll have a better idea of, most of the fiscal year has passed. We have an idea of, how many actual applications we did get. And if they, for some reason, didn't get as many as they thought they would, they might, move it forward a bit to try to fill in what they didn't get. But that's why filing dates usually don't move very much throughout the fiscal year.
Got it. Good information for me. Last question, Rahul. I understand maybe just one question is, as we saw that between the range of 2011 to 2015, the dates were open as of today for EB3 category. A lot of people from EB2 have moved to EB3.
Yes, and there's another thing.
Yeah.
In the other thing, a lot of people expected, include I, was expecting that the big companies would not do the downgrade. I was very surprised that even the large companies, huge, like Fortune 100 companies, also have done the downgrade. Okay, keep going though.
Yes. So can we see a forward movement in the EB2 category now? Because they have been, is that my understanding that in USES, there are 2 applicants for a same person in EB2 as well as for amendment in EB3? Will that be a count of 2, or the EB2 would be nullified, and if they get an adjustment of status done for EB3 category in coming 6 months?
EB2 is not nullified. At least 95% of the good lawyers, I mean, I would consider all these 95% of these lawyers good lawyers, filed. They did not file as an amendment. They filed as a new application. In other words, EB2 is still active for them. EB3 is also active for them. So the switching back and forth of this EB2 to EB3, we may have to conduct a special session for it, because it's a little bit conflicting, and it never happened before, where upgrading, downgrading, these things never happened. Normally the downgrading things happen with Chinese nationals. We just downgraded to EB3 and filed the adjustment of status. We also, so we have to switch. We have to see if can we switch the same application into EB2, how the immigration is going to react to it. Will they actually approve it? Will they tell us to refile the entire application? We have to see how they are going to act. But the EB2 is not inactivated for most of the people unless they filed it as an amendment. I'll be very surprised if any lawyer has filed it as an amendment. Most of them has filed as a new application, which is the right way of filing it.
So assuming the person who had done the downgrade and he got an EAD, still he's eligible for EB2's final date of action? If he gets an adjustment of status done.
He could be. Now he's definitely eligible. Now the question here is, does he need to file a new adjustment of status, or can he use the existing adjustment of status? For sure, we can say that if he files a new adjustment of status, he's eligible for it. Now, can he use the existing adjustment of status? That is to be seen if we can do that. Okay. I want to inform Mr. Satyanarayana Murthy's call was that Chad Wolf did not sign the specialty occupation regulation, though. It was the Mazzilli, the general counsel, who was acting at the time. He signed off on the new regulations. It was not Chad Wolf who signed off on the new regulations of the specialty occupation. One of my business partners, Stephen Brown, has just updated me on this. Okay. Let's go to the next caller.
Thank you, Rahul. Thank you.
Yeah. My priority date is November 2014 for EB3, and submitted my I-485 by end of November 2020, but not received the receipt. Does anything need to worry about?
No. I'm expecting between 6 weeks, but Rebecca corrected me, which is right way of correcting, is that she's expecting 8 weeks time to get a receipt notice. So he's fine. I don't see any problem in it.
My current H-1B is ending on June 30th. Am I eligible to file before December 8th? Which is like more than 6 months.
I'm sorry, my current? No, you can't file an extension more than 6 months unless it's an amendment plus an extension.
Okay. Can you please elaborate about the marriage to I-485 EAD and AP for kids above 16 years?
If 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 any of the family members use, especially the main applicant, okay, if he uses a EAD application or AP application, then the H-1B is considered to be invalid. They are no longer on the H-1B. And if the kids use the EAD and advance parole, okay, then their H-4 is considered to be null and void. Then they are considered to be married to this application called adjustment of status. Here is the problem when they get married to this application. You remember, Kishore, that we filed adjustment of status. A lot of people remember that we filed adjustment of status in 2012 for the peoples whose priority date was May 1st of 2000, before May 1st of 2010. And guess what, though? Even as of today, right now, the priority date is only October of 2009 for the final action dates. So that means that they never got their green cards yet after 8 years. So assuming if the 16-year-old kid, because previously it was 8 years, if the 16-year-old kid, while his adjustment of status is pending, becomes 21 years old, and his final action dates never become current. Remember, previously the final action dates were current. There was no final action dates and filing dates. The final action dates and filing dates came into picture in 2000 and, 2000, which day was it, Rebecca? 2015, is that right, Rebecca? Final action, filing dates and final action dates only came in 2015 September. So if if the final action dates never become current, this kid will be kicked out of this adjustment of status unless there is something which is I-140 has been pending. There is a little bit complex formula for it, and this person need to check with a lawyer before he does anything. So this kid will be kicked out of the 485 application. When the kid uses the EAD and AP, he's married to this application. That means that he's not an H4, so he cannot move into the F1 visa. So when he gets kicked out of the adjustment of status and he cannot move to F1, what will happen to this kid? The kid will go out of status. The family is fine. The mom, dad, and the younger siblings are fine. But this one kid will get kicked out of this application. That may happen. We have seen that happen several times. So we do not want the 16-year-old kid that you have to be married to this application. We may even not want you to get married to this application. That means that we don't want you to use the EAD and AP.
Okay. Next question from another member. This summer, I received an H1 extension approval for 3 years. I still have the same job. Last month, my EB2 AOS was filed with AP and EAD for the PD May 5th, 2010. Do I need to do anything with respect to any new regulations, policies?
No, he's good. I mean, he has a EB2, hopefully so, and he has been waiting for. It doesn't matter whether EB2 or EB3. His May 5th of 2010. He's good. Everything looks good to him. I mean, he doesn't have to do anything. His new regulations are not affecting him because he has H1B approved for the next 3 years. By the time, hopefully, he should get the green card. Even if he doesn't get the green card, he should be able to get the EAD and the AP, and then he can get married to the adjustment of status. I don't see any problem with him. He doesn't have to do anything. Everything looks good for him.
Cool. H4 and H4 EAD is pending for approval, and my wife need to visit India and get it stamped on my visa. H1. What will happen to H4 and H4 EAD applications?
The H4 and H4 EAD application can continue to be existing. They don't have, since it's an extension of the H4, is right? It's not a transfer to H4, is right, Kishore?
Yeah.
Assuming that it's an extension of the H4 and H4 EAD, he should not do anything with the H4 plus EAD. She can go, or he can go and get the stamping done of H4 and come back. Eventually, this H4 will be approved along with the EAD, okay? And then he can use the EAD at that point of time.
Cool. Mr. Sai Krishna, you are unmuted.
Can you hear me, Kishore?
Yeah.
Yeah, thank you, Kishore Garu, Rahul, and Rebecca. Yeah, my current H1B is valid through June 3rd, 2021, and I'm currently in Texas only. Like my current project is going to end maybe December, this December. So I have to file an extension. I'm searching for another project as well. I may get it in another location, not in the Texas one. So this is the situation. So which would be the better option for me so that I will get an approval, extension approval. Okay. And adding to
What
that
do you
one,
mean?
my back.
What do you mean better option? You don't have much option. I mean, you have to get a job before December 8th and file it. If not, I mean, which doesn't look to be possible. So you will have to go in the new regulations unless the court stops it.
Okay. Yeah, adding to that one, actually, my background is on graduation is BTech is on electronics, and but I'm currently on the IT sector. So will that impact anything on this? Like why? Because previously this specialty occupation is there, but I was able to go through that one and got approvals. So how difficult is this situation currently
Okay,
compared to the earlier one?
we call it electrical engineering here instead of electronics. Rebecca, what do you think so of the new regulations and the specialty occupation for the electrical engineers in the software profession?
Yeah, the new specialty occupation regulation specifically kind of targets individuals whose degree fields of study don't directly relate to the occupation that their H-1B is being filed in. So it does seem specifically aimed at the type of situation for IT workers where a lot of them have their degree backgrounds in an engineering field that is not that isn't software or computer engineering.
But let's segregate between electrical engineering and let's say mechanical engineers or civil engineers. We'll discuss that. Electrical engineering
and also,
is
sorry to interrupt you. I have almost 16 years of experience.
We are aware of the experience. We are aware of the experience. Everybody has experience. So what electrical engineers, do they have a better chance compared, to fight, Rebecca, compared to mechanical engineers or civil engineers?
A better chance.
We are speaking of only people who have more than 12 years of experience.
Yeah, electrical engineering is definitely more related to an IT occupation than some other engineering fields like chemical or mechanical engineering. But I have still gotten RFEs for people who had a master's degree in electrical engineering, have had 2 or 3 H-1Bs approved for them before without it ever being questioned. And then this year, there's an RFE asking how they're qualified for their position. So it's not 100% guaranteed that electrical engineering is a qualification for an IT position according to USCIS.
What are the probabilities now with these new regulations becoming effective on December 8th for the mechanical engineers, chemical engineers, and all other engineers? Let's leave the electrical engineers out for a while.
If the rule goes into effect and it gets applied the way it's written, it's going to be very difficult, is my opinion, to get an approval for an IT position for a software developer.
But Rob, what about the experience where we've been telling a long time ago that 3 years of experience is equal to 1 year of education, and the gentleman has 15 years of experience. In other words, he does have a 4 years of degree based on the 3 years. 3 years of experience is equal to 1 year of education. What about that?
Yeah, so it will be, there are more options if you have several years of experience in the IT field already, because you can obtain an evaluation that is based on your work experience.
But under new regulations, what difficulty do you think so they will face if we get the experience-based evaluation?
USCIS could still challenge it, based on the new wording in the regulation. That has been our kind of methods so far in responding to the RFE that I described earlier is getting an evaluation based on experience plus academics, and showing that their work experience plus degree is the equivalent of a bachelor's or higher in information technology or a field that is directly related to the position. I would say that that could still be challenged under the new specialty occupation rule. We'll just have to see.
Okay, sure.
Yeah. Mr. Prem, you are unmuted.
Hey, thanks, Kishore. Hey, Rahul, thanks for the time. I just did my downgrade without an advance parole. So how soon can I do if I want to do the advance parole? Do I have to wait for the receipt notice?
Yeah, just wait for the receipt notice.
And also, I have my stamping. So if I need to travel, can I travel in the next few months, or I have to wait for the receipt notice again for that?
I would recommend to wait until the receipt notice comes in, but it's not necessary that you have to wait.
Okay.
You know, it's not that receipt notice is going to take a long time right now. We are expecting the receipt notice to come. You know, you filed a month ago, so maybe a month it will take. So I would recommend to wait until you get
Okay.
receipt notice.
Okay. All right. Thank you.
Next question from chat window. For someone whose AOS was filed in EB3, do you recommend to use EAD and AP or continue using H1B if it has been extended?
It's going to be a tough question though. First thing is that if somebody has filed a downgrade application, we strongly recommend to file a premium process and get the I-140 approved before they take any decision though on getting married to the adjustment of status. With regards to the people who I-140 is already approved and their adjustment of status is there, it's going to be a personal question. Generally, if I were the applicant, Kishore, I would like to get married to this application. I don't want the burden what Rebecca was telling about the specialty occupation. I don't want the H-1B approval to be every year I have to go for the H-1B approval. I don't want all these things every time I have to. I just want to file an EAD and AP. And it is so easy to apply for EAD and AP. Believe me, the fees that lawyer charges is pennies as compared to the H-1B. And there's not even a filing fees for the EAD and AP right now. You can freely file it. It will be given to you. You don't have to give them an end client letter, a vendor letter. But Rebecca is telling now the education evaluation and the experience evaluation, all these things. I mean, it's going to become tough. I would like to personally get married to the adjustment of status. That's what I would prefer. But, you know, some lawyers tell differently. It will be more, I will not advise, especially on this Zoom call, what he should do. If they have a personal consultation, then I will go through the situation to see if there is any faults that he may have in his I-140 application, any faults that may occur. But I would say that unless there is some criminal history, unless there is some issue with regards to the I-140 underlying application, anything that is, for example, a 3-year degree has been used, it should be evaluated by a lawyer. And most probably, I normally recommend 98% of the time when I have a personal consultation, I recommend them to get married to their adjustment of status.
Yeah, thanks, Rahul. Mr. Sujit, you are unmuted.
Yeah, thank you. Thank you for arranging this webinar call. You know, in the month of November, my company's attorney applied for change of status, EAD and then AP for myself and then for my family. So if I'm not planning to use the EAD or AP for next 2 years because I have a valid H-1B visa until 2021 December. So if I'm not planning to use this EAD, then can my wife use this? I mean, once she gets the EAD?
This is a question that comes up very frequently. Now you understood. So can she get married to this application? You not get this married to this application. The question that pops up, the next question is that, are you willing to get the green card without her?
No. Definitely
well,
not.
Then practically you both are get married then.
Right.
Because you don't want to leave her alone in the desert, is right? So
Correct.
either you die with her or you live with her. So if I were you, if she has used it, I might as well use it too.
Okay. So, but as long as your H-1B is renewing, it's not really required. for me to use EAD, right? And
no, it's not. But once she's married, practically speaking, about you're married to this application, to irrespective of whether you use the H1B or not.
okay, got it. So my second question is, let's say if let's say I'm not gonna get married to this EAD, and can I discontinue renewing EAD for, let's say, maybe a couple of years or maybe more, and then start resuming it again?
I do not recommend it. Since it's free, right? You're not even paying any money. There is no documentation requirement, no vendor, no nothing required. Have it in the pocket. You
Okay.
never know what emergencies will pop up.
Okay.
I would recommend strongly to have it in your pocket at all times.
Got it. Thank you. Yeah.
Okay.
Rahul, I see it is 7:05. So should we go with another 1 or 2 questions, or shall we close?
Sure, we can go for 10 more, 15 more minutes at the most.
Sure.
How about that?
Yeah. Mr. Manoj, you are unmuted. Manoj Kumar Vartarajan.
Yeah, thank you. So, attorney, so I work for employee A, and right now, like, I moved to employer C. So my employer A actually filed my adjustment of status very recently, considering like, chances of like me getting a green card through them is like more, and then like the intent is very clear. Like I may join them in like after I receive my green card. But assuming if my green card is getting like say delayed like 2 years, 3 years, 4 years, and my current employer who is willing to sponsor my new green card, can they directly like go ahead and apply I-485 and then port that, considering this the position is the same in two places? Or like
it's not I-485. It's considered to be as I-485J supplement. So this new employer is going to take over the responsibility, at least after 6 months. You must have a valid job offer from your existing I-140 application for at least 6 months after you file the adjustment of status. After that, the new employer can file the 485J supplement and say that they will take the responsibility of the adjustment of status. Rebecca, is it advisable in this situation to do, or do you advise him to go join company A? I know I'm putting you the tough question.
Yeah, I know different attorneys have different opinions on this question. I tend to recommend joining employer A, joining the employer that filed the I-485J supplement, or the one who did the I-140 downgrade, whichever company that did the I-140 that allowed you to file the I-485 application. I am estimating that there's going to be a lot of scrutiny, more scrutiny than usual, even under a Biden administration. I'm estimating scrutiny on this exact situation, on whether there was a genuine intent to join company A when they filed the I-485J supplement for you, because that's what that form, that J supplement that you personally signed and employer A personally signed, it required both signatures, both of you certifying that there's this job offer open at employer A and that you intend to join them. If you never actually join them, if you never make any moves to transfer your H-1B over to that company, or after you get your EAD, if you never move over to that company, but instead you stay with the company that you have been, that company starts a green card application for you, and you never join company A, I feel like that's going to be looked at with quite a bit of scrutiny later.
I'm also worried, Rebecca, with this new policy changes that came last week with regards to the 485J supplement. They clearly pointed out the intent of the employer and employee. They reiterated, especially the Trump administration, before going, he's trying to damage as much as possible the immigrants. And that may be an hindrance also for this gentleman not joining company A and using company C as filing a 485J supplement. I'm a bit worried about that too.
Okay, in along the same lines, if in case the employer C started a fresh green card process and then like go through the perm
If he
labor.
started the perm labor and all those things, you should not get married to this adjustment of status. Okay. Then you have to file a fresh adjustment of status at a later time. Then we have no problem with you.
Understood. Understood. Okay. Okay. Makes more sense. Makes more sense. So I can continue working with the current employer and go through the regular green card process of like perm,
Yeah,
I-140 and
but who knows whether or not your priority date will remain like this or it will go back like the way it went back in 1996. It went back in 2001. It went back in 2012. When it goes back, it takes like 7-8 years sometimes to come back again. So that's another problem you may be having. But yeah,
okay.
having to be on a safer side by filing a labor certification with your company, I think so. That's a very good step that you might be taking. I mean, nothing.
Okay.
You're not going to lose anything.
Thank you, Tony. That's helpful.
Yeah, Nipa, you are unmuted.
Yeah, hi, Umesh here. On my priority date is November 2014 for EB3. I applied for I-45, ED, and AP, and for my spouse also. My daughter age is now 15, and I applied for I-485 and AP. Is there any issue for her?
No, just because you applied AP, you could even apply for EAD also. If I were you, apply for EAD too. It's free. Why not? If you apply for EAD and AP, that's fine. But using those EAD and AP for your daughter and also for you too, I would recommend to wait until the final action date becomes current for you. Remember, there was a gentleman asking, should I get married to this application? In your case, I would not recommend either you, your wife, or your daughter gets married to this application until the final action date becomes current, because we don't know if the final action date becomes current by the time your daughter becomes 21 or not. As I said, that it's very risky to get married. I would not get married, but keep filing the EAD and AP. There's nothing wrong in it.
Okay, so okay, and her H4 also in right now in the extension.
That's
So
fine. That's good.
that's fine. Oh, okay. Thank you so much.
Kumar, you are unmuted.
Yeah, thanks, Kishore. Hi, Rahul and Rebecca. Nice to meet you. So one question is regarding the H-1B max out and green card process. So the scenario is through company A, I got Perman I-140 approved, and within 6 months, I moved to a company B. Okay, and I got a 3 years extension, and my H-1B 6-year max out is coming in a month. So, and if my company A revokes the I-140, can I file Perman I-140 within the 3-year extension which I got? Is that possible?
That is possible. I don't see anything wrong in you filing within that 3-year, filing a labor certification I-140. One question that I have is that, do you know, when did you got the I-140 approved?
So I got it approved last year, September timeframe. Yeah.
Do you know if it's been withdrawn or not withdrawn?
Sorry, it's this year, September. So I don't know right now, because when I looked at the USA site, it still shows it's an approved status only. But how do I able to check after the 6 months get over? Yeah.
Good point. Good point. After your 6 months is over, I mean, Kishore, your audiences are well educated, Kishore. After your 6 months is over, I would want you to file a Freedom of Information Act. I want you to note it on Google, FOIA USCIS, okay?
Okay.
And you can fill an online application. They'll take about 2 or 3 months for you to get it. The entire I-140, and then you will come to know when they withdrew it. You don't have to inform your ex-employer what you're doing.
Okay.
Rebecca, with regards to, do you think so there will be any problem? Because if his 6 years max out and his 3 years H-1B, he already got it. Do you see any problem in his filing a labor certification with company B?
No, that should be fine.
Okay.
Okay. And recently I tried to get it through the Information Act, and I see it's still approved, but I still have.
It It doesn't matter what it says right now, whether it's been withdrawn, whether it's not withdrawn. You need to do it after 6 months.
After
We need
6
to know
months.
whether it's been withdrawn after 6 months, not right
So
now.
we can raise again the same request one more
Absolutely.
time. Okay.
Absolutely, you can. It's free. It's online. It takes 10
sure.
minutes. You already done it.
Okay. Thank you very much, Rahul and Rebecca, for the answer.
Thank you.
Shekhar, you're unmuted. And the last question for this evening.
Yeah, thank you very much for giving the opportunity to me. And just Rahul has answered my question in one of our previous callers' question. But only one thing is, according to the USCS manual, saying that the child CSPA age calculation as per the filing date, it was saying. But 2015, prior to 2015, we don't have the final action date and filing date. After 2015 only we have this one. But according to the USCS manual, it is saying that the filing date will be considered as the child CSPA.
No, they changed the manual in 2000. After 2015, they changed the manual, and they changed it again last week.
Yes,
because
last week also they changed.
They changed it, and they said it's not the filing date. It is the final action date that will freeze the kid's age.
Okay.
And we have had denials of the adjustment of status based on that.
Okay. And one more question on that. Currently, my child age is 14 years. Can I go ahead and use EAD and AP once my I-485 and EAD AP approved or not? Because 6 years or 7 years time left.
I know. That's going to be tough to answer. What do you say, Rebecca?
I am not comfortable making that recommendation.
I'm not comfortable telling you to get married to this application. I'm not comfortable.
Okay. And one more question. According, my wife is EB2 2016. Mine is 2014 December. Currently, I filed mine and my family, entire family, under 485.
Including your wife?
To EB3.
Including your wife?
Yes, including my wife. If my company, once again, if EB2 will becomes current, if they are not ready to port back to me, if can I use my wife's EB2
485
application
to file the entire application? If you are not married to this adjustment of status, in which you know what a marriage means.
Yes, yes, I got it.
We do not see any problem whatsoever at all to file the entire adjustment of status again with your wife.
Okay. But we cannot able to only file 485J or something?
No, because you are the main applicant here. She will be the main applicant there. A 485J supplement is not enough. You'll have to file the entire application again.
Okay. Thank you.
In your case with 14-year-old kid though, I would be a little bit more defensive and would not like to get married to this application.
One last question by Mr. Kush.
Yeah, hi Rahul and Rebecca. Yeah, thanks, Kishore. So I have a question like, in January 21, my H1B will be maxed out. The good part is that my 140 just approved last week. And I have to file and I have to file the H1B extension, now, but my current project is going to be finished in December last. So should and obviously I have to find a new one. If just suppose I'll get new project for 6 months or a year. So for current project, can I file extension right now? I will get for 3 years, or I have to wait till January. Am I, you have to find out, and then I have to file for my new project. So what's the recommendation here?
How are you 100% sure it is going to be over in December, whatever it is?
Means my current project, that I got to know from my client, it's going to finish in December.
Are you 100% sure?
Yes.
How can you be 100% sure? You don't even know if you're going to be alive tomorrow, 100% sure or not.
They've shared a mail. They sent a mail that you're getting rolled
out. Can they not undo it?
Right now, no.
You're not helpful. The answer to the question is no, you can't file an extension. If you're 100% sure, if you're 99% sure, yeah, there is a possibility maybe, but you're like 100 and you're not cooperative with If you're 100% sure, there's nothing you can do. If you're 99% sure, yeah, probability there is a chance, but you're 100% sure there is no chance.
So if there's a 1% chance, I can file extension for the current and I will get for 3 years?
Well, you could discuss with the lawyer on that though, and see, because normally what we see is that the projects get closed and they kept on getting open. I mean, that's how many times have we seen the project is only 3 months and then we see after 3 years, the guy's still working there. What are you doing there? 9 years, the guy's working there.
Got it.
So if you're not, if you're 100% sure, there's nothing anybody can do.
Okay, thank you. Thank you so much. Yeah.
Okay.
Thanks, Kishore.
Yeah. Thanks, Rahul, Rebecca, for taking time. Great.
Thank you.
And
thank you, Kishore.
Lots of questions.
Yeah, very educated, very nice questions, Kishore, from your team. Thank you.
Thanks, Rahul. Yeah.
Thank you for having us.
Still, there are a lot more questions, but I know you already took more than 15 minutes. So.
Yeah.
And we have these daily sessions, and also we have weekly. Rahul and Emily and team, they do weekly Facebook lives, so you can always go to RN Law Firm and you can subscribe to those. Or you also get all the notifications in our WhatsApp groups. Yeah.
Yes.
Thanks everyone. Thank you.